Hello, everyone. This is Kristen with the LTRC. Thank you for joining us for From Crypto to Credit Cards, how online payments work and how to use them to maximize your receivables. With our sponsor, LawPay, as part of the LTRC Industry Insight Series held every Wednesday. Our speaker today is Jordan Turk. Jordan is a practicing attorney in Texas and is also the law practice advisor at LawPay. Prior to LawPay, Jordan works with a high-asset family law firm in Houston, Texas. Her family law expertise includes appeals, pre- and post-nuptial agreements, as well as complex property division and highly contentious custody cases. In addition, Jordan has given CLEs across the country about online payments and trust account compliance. Jordan has authored and co-authored many articles that you can find in the Texas Bar Journal and on lawpay.com/blog. Passionate about giving back to her community, Jordan makes a point of taking pro bono cases whenever possible. In 2019, she was honored to be the recipient of the Harris County Bench Bar Pro Bono Award for outstanding service by an individual. Thank you all for joining us. We will now begin the webinar.
All right. Thank you all so much for joining me. I'm down here in Austin, Texas. So you can imagine it's about to get super hot down here. Not looking forward to the summer. Okay, so I'm about to give a lot of information in a very short period of time, but if you have any questions whatsoever, put them in the chat or put them in the Q&A section, and then also feel free to email me. But really what I want you to leave here with is a basic understanding about how every single type of online payment works and how to use them to your advantage, and also things that can crop up along the way that you need to know about, like what's a chargeback and how to beat a chargeback and things like that. So hopefully by the end of this, you will feel a little bit better about online payments. Alrighty, and let's get into it. There's me. You already heard about me. A little bit more about LawPay. So we are an online payment solution. So essentially, if a client comes into your office, wants to give you $5,000 via credit card for your retainer, which, yes, please, we help facilitate that process, keep you compliant with your state bar, all that jazz. So here's what we're going to talk about. Again, very short period of time, but I'm going to take you through everything. So how payments work, what is, for instance, surcharging? So, hey, can I pass on, for instance, credit card fees to my clients now? Is that a thing that we can do? How to actually accept online payments, what to do when a client contests a payment, things that you have to watch out for with your state bar with regard to compliance issues, and then also how to improve your processes and strategies for your payments and collections. So a big part of what I did for my prior firm and what I figured out really quick was that my monthly bonuses were tied directly to my receivables. So meaning I could bill 200 hours a month and, completely just almost kill myself, doing that billing, but then it never mattered unless I was actually collecting on those amounts. So you can imagine that I got very adept very quickly at collecting from non-paying clients, because for some reason, I don't know why, but a lot of clients never want to pay their divorce attorney. It's so weird. I don't know why I'm not everyone's favorite person. Strange. Okay, so types of cashless payments and how they work. So first of all, we have a wire transfer, super simple. So it's a bank-to-bank transfer. So this is why you get funds faster via a wire. It's because they don't have to go through a clearinghouse or a network. It's just a pure bank-to-bank transaction. And then as far as ACHs go, so that's what they also call an e-check. So that actually goes through its own network. So it goes through the ACH network, which is why it takes longer to get those funds than, say, a wire transfer. And then cryptocurrency, which is a big thing that I'm seeing a lot more now. We had a lot of clients that would ask to pay via crypto, and then we would always kind of tell them no, because I think, for one, our COO would have had a conniption fit, and it was so new at that time too. Nobody knew what to do with it. But a little bit of background about crypto. So for IRS purposes, crypto, or NFTs, things like that, crypto is not treated as currency per the IRS. It is treated as property. So this means that consideration is due at the time of the transaction, and not only that, but cap gains taxes are due also at the time of that transaction, which completely fine. Who cares, especially if the payor is doing that and dealing with all that. The issue then comes from, once the law firm has that crypto, if it increases in value at all while the law firm has it, when the law firm goes to trade it away, they're going to then be responsible for the cap gain taxes on that crypto that they've been holding for, whatever period of time they want. So that's the problem. It just kind of creates this huge accounting headache when it comes to it. Nobody really wants to deal with it. Now, there are services out there now that do all of this for you and calculate all of that for you. And so you can use that, but they're still kind of new. And also remember too, crypto is super volatile, as we've seen, anybody has seen if you have, anything pulled up from the last few years about what's been happening with it. So that's another issue. Also, there's federal and state tax implications too. So if you're looking for my opinion, whether to take it, I would say no, unless it's absolutely just a windfall for the firm and you're comfortable with it and you're comfortable with being able to explain it to your accounting department, or they're able to explain it to you and do it correctly. So for right now, I would say I don't accept it when clients ask, but I will say that most payment processors are going to be looking at this and they have their eye on the horizon, because I think it's clear that crypto is not going anywhere. So I would probably hazard to guess in the next few years that you'll see it be incorporated into a lot of payment processors so that you can take it from your clients. But for right now, just keep in mind that it's not currency and that it's property, and you have to treat it as such if you're collecting it for your law firm on behalf of your client. And then also we have credit card transactions, and that's a multi-stage process. So as far as that goes, credit card transactions, typically they'll clear in a couple days. So everybody knows how this works. Client pays by credit card. It goes and gets sent to this acquiring bank, and then it goes through the credit card network. So that's Visa, Discover, Amex, and all that. And then that gets sent back to the issuing bank, and then they'll pay you. So that's why it takes so long. So everybody wonders, oh, why do I still have to wait at least a couple days for these funds to clear and settle in my account? And it's because it has to go through this process. And some places will say, hey, if you pay us a little bit more, you can get it cleared in a day. And that's basically the processor saying, hey, we know you're good for the money, and we'll put this up for you. But it's not that you're actually getting that. It's not that anything goes faster if they say, hey, these funds will be in your account in a day and settled. It's that they're basically putting up the money for you, because you can't rush what goes through the network. Okay, so what's the difference between an ACH and a wire transfer? So one, there's costs. So wire transfer, the fees typically range from about $0 to $40. Also, you should be getting a copy of this. A lot of information. You'll be getting a copy of these slides. And if you do not, please shoot me an email and I'll send them to you. But as far as ACHs, so a lot of them have either they do a percentage of the total transaction, or they do just a flat fee, i.e. $2. But the sender is the one that pays. Whereas with wire transfers, typically it's the recipient that does. Also be very careful with wire transfers. And I might mention this in a little bit too, but wire transfers are final once they are sent. And so we had a whole issue with this in a case that we had. And basically our client had to say bye-bye to 250 grand that had been wired by the spouse, who was not a good person, and he wired it to a builder in California. And of course, we were not able to recall that wire transfer, because once it is sent, it's basically done and there's no getting it back. So super fun to try as a Texas law firm to get that money back from a contractor in California. So you can imagine that we never saw that money ever again. Super great. Family law is fun. All right, so processing fees and surcharging. So first of all, a lot of people are like, hey, why do I even have to pay these fees for the credit cards? What is this? So when they say, hey, it's 3%, to run this credit card, what actually makes that, what actually is composed of those fees is what I'm trying to say. What are those fees composed of? There we go. But as far as what happens, so what makes up your rate? So the credit card processing rate, let's say it's 3%. So minimally it'll be your dues and assessments and your merchant processor fees, i.e. your LawPay fees. But the vast majority of that is your interchange fees. And these are fees that are set by the credit card brands. So for instance, Visa, Amex, Discover all come together and make there's about 300 little fees that go into these interchange fees. And they're saying, hey, this is what it costs to run these cards. This is what it costs to do the network. This is what it costs to cover all the fraudulent transactions, things like that. So that's what goes into those interchange fees. Does it sound a little weird? Because who polices the police if the credit card brands are the ones that are actually making these fees? Yes. Have there been antitrust lawsuits with regard to this? Yes, which is also why you can now surcharge, and we'll talk about that in a minute too. But other factors can affect interchange rates too. So think about it this way. Credit cards, want you to have the most secure transactions possible because they don't want to have to cover fraudulent transactions if they can help it. So the more secure you can make a transaction, usually the lower the interchange rate will be. So for instance, if you have somebody that will, oh wait, that'll be on the next step. Anyway, sorry, I'm getting ahead of myself. But also what'll affect it too is the card type. So rewards cards are going to be a higher interchange fee than just a regular basic Visa. The merchant type is going to be different too. Walmart's going to have a different rate than a mom and pop, coffee shop, things like that. And again, the more information that you provide, sometimes they ask for where you live, your firstborn, things like that. The more information they ask that, because the more information they can provide, the less fees or the less processing fees that merchant has to cover usually. So let's talk about surcharging. So as I said before, there were a bunch of antitrust lawsuits some years ago against the credit card brands because, again, who polices the police? And what came out of that was this settlement that also included provisions now where most states can start surcharging, but not all. There's about 2 states, I think, maybe 3. Florida might be in there, depending on the bar rules right now. And I think that's all changing. But pretty much every state now, you can pass on your processing fees to your customers, which is great if that was the one thing that was keeping you from offering online payments. So, but still a little bit of a minefield because you still have to adhere to some rules. Like for instance, you can't surcharge more than the credit card processing fee. So basically you can't profit off of that. If it takes 3% to process that card, you can't go and tell your client that it's going to be 5% if they want to pay by credit card. So have to do that. Obviously you have to disclose to the client what this is, big bold letters, things like that. You also can't surcharge a debit card transaction too. So there are a few little nuances to it, but you can absolutely do it, especially if your state allows it. And what was happening at that point is a lot of lobbyists were going state to state once this lawsuit settlement came out, and they were basically kind of beating down every law that was on the books that originally had prohibited surcharging. So that's why in the past 2 years, you've basically seen every state kind of fold when it comes to that and overturn these laws. So interesting to look at. If you have a question, let me know. My personal opinion on surcharging is to not do it just because I know how my clients are. And my clients don't like to feel nickel and dimed. And I'm also one of those very petty people where if I'm online and I'm trying to buy a $400 pair of shoes, I'm ready to spend it. Let's do it. It's reckless. It's okay. But then if I see that they are trying to charge me $5 for shipping, I will not buy that pair of shoes. Because now I just feel like they're trying to nickel and dime me. I'm paying you $400 for these shoes that I already don't need, but I'm willing to part with my money. And now you're saying no, an extra $5. And so I will legitimately not buy the shoes. So just my personal opinion on that, but it really honestly depends. Maybe you have a clientele that does not care. And so obviously I want to pass that on to my client. My clients are already not wanting to pay me. And my goal as an attorney, especially for a family law attorney, is I want to reduce as much friction as possible between my clients and their pocketbooks. And if that means that the cost of doing business is a 3% credit card fee, I'll pay that all day long. And I'll incur that cost all day long if it means that I can get paid right then, as opposed to a client saying the check is in the mail and it never actually is when it comes to family law. Also, too, family law, it's just very volatile, right? There could be 100 grand in an account one day, and then that account is completely wiped out the next. Client could say, oh yeah, I have $3,000 for you. And then the next day, oh no, it's gone. Because things just happen, nefarious things, especially when it comes to the spouses and family law cases. So for me, I just want to get paid immediately. So as quickly as possible, how do I get that? And usually it's just me taking a credit card, although I will take a wire transfer all day long. If we want to do that. How to accept cashless payments. I'm just going to speed through this because I think everybody kind of knows. Wire transfer, client just fills in information that you have provided. And so make sure that that is correct, because I've seen that backfire on a couple people. So make sure that you have a safe place that you put that, like for instance, on your firm drive where nobody can override what you've written in there for the wire transfer transactions and the instructions. And so keep that in a secure file, and also where no one can edit it if they're sending it out to the client for how to pay via wire. And then also ACH transactions, super easy. We've all done it. We just fill out our own bank account and routing information, credit card transactions. We obviously all know how to do that because we do it too much. So what to do when a client contests a payment. So I've already mentioned wire transfers. It's virtually impossible to recall that payment once it's sent. There are very specific circumstances that you might be able to get it back, but generally no. So if you are the sender, i.e. the law firm or anything like that, and you're sending that money, you need to triple check, quadruple check that information that you had as far as the routing instructions are concerned. Disputed credit card transactions, everybody's favorite. So these are called chargebacks. And what happens at this point is a client will say, oh no, I never agreed to pay Jordan $5,000. I'm disputing this with my credit card. And does it enrage me? Yes. Has it only happened a couple times since I've been in practice? Yes, which is nice. Have I won both times? Absolutely, yes. But essentially what'll happen is once those funds are disputed, the credit card brands or the banks will go in and freeze those funds until they can figure out to whom they belong. And what do you do as the attorney to win this chargeback? Super easy. I'm going to show the fee agreement that I had where the client signed on and said, oh yeah, I agreed to pay Jordan $5,000. It's in my fee agreement. I'm also going to show them my billing statements where it showed that I've worked that case and I've billed for it. And that is the easiest way to win your chargeback. So it's really just making sure that you're papering the file and that you have everything in line. But you're going to win that every single time if you can prove that, no, the client agreed to this and yes, they owe me this money. And also there's a lot more detail in these slides. So really, if you're interested in the nitty gritty, like, hey, what do the timelines look like? How long does a client have to contest these? Refer to these. They're great, but I'm biased because I created them. And then also too, a lot of people say, oh, if I have to defend a chargeback, they get a little leery about it because, hey, I might have to reveal some privileged information, that the client has revealed to me, things like that. So the ABA actually has a rule 1.6 that says, hey, you can do it if it's necessary to establish a claim or defense. And then disputed ACH transactions, the only thing I want to hit on this, because we only have about 10 minutes left, is that they are riskier than credit cards. So for e-checks, if somebody disputes it, that's fine, but the big difference is if the transaction is disputed within 60 days, the funds are sent to the client to hold. And I don't trust my clients as far as I can throw them. And so if it's within that 60 days and they get it, and even if I win at the end of the day, I'm still going to have to go and try to get those funds from the client, because what are the chances that those funds are still in that account once they say that I win? And maybe that's just me being jaded, having been, in family law for 5-6 years at this point, but I just don't trust anyone. And so I would rather have a dispute over a credit card rather than an ACH. That being said, they're very rare as far as chargebacks go. And if you're getting a ridiculous amount of chargebacks every day or a ridiculous amount every month, then that's really where you need to step back and evaluate your practice. Because I think in the 5 years that I've done it, I've only had 2, and I've had no ACH disputes. So something to think about for that one too. All right, so how to avoid possible state bar sanctions regarding your trust account, because no one wants to be here. But so the ABA has a model rule 1.15 for safekeeping property, which every attorney knows, because we either, this was a question on your MPRE or it was a topic in your professional responsibility class. But essentially it says you need to keep your client's property separate and apart from yours, meaning, hey, client comes in to pay me to retain my services, that goes into a trust account. If I'm paying, my employees and doing payroll, that's coming from my operating account. I cannot trust my trust account, or cannot touch my trust account, I should say. And so what does this mean when it comes to credit cards though? So this is where a lot of people get into trouble. So no matter what, you have to keep your trust account and your operating account separate. They cannot be commingled, right? That's the word that everybody knows when they learn this. But what does it mean for credit cards? So when somebody comes to pay you and pays via credit card, and let's say you're not using anything legal specific, you're just using a random bank who's dealing with your trust and operating accounts. So they don't know what needs to happen with regard to that. So a client comes in, here's $5,000, fee agreement says $5,000, perfect, let's get started on this case, I need this money. And so the $5,000 goes into your trust account. The problem is your bank is going to automatically deduct the processing fees from that trust account. So they're going to deduct, that 3% from that $5,000, and they're just automatically going to take it. So your problem as an attorney is this client signed a fee agreement that said that they just paid you $5,000, but actually there's only $4,850 in there. So unless you were keeping a little bit of money in there to float you for those processing fees of your own money, basically it's almost like you've just committed theft of client funds, because there's $5,000 does not exist. It's not in that trust account. So that's where it becomes a little bit tricky. And unless you just have the forethought to put money from your operating account into your trust to cover processing fees, it's honestly just a little bit of a headache when it comes to accounting. So what LawPay does instead is we say, there will be no third-party debiting from your IOLTA account from us. So we don't touch it. So a client pays you $5,000, $5,000 gets put into your trust account fully. And then once a month we go and we debit the processing fees from your operating account. So we never touch, don't know why I'm saying never trust your trust account, but we never touch your trust account. And that's the key. So when you are shopping around for processors, whomever you end up choosing, find one that caters specifically to law, because this is what's going to happen is, and what's going to land you in a problem with your state bar. And what I look for at the back of the Texas Bar Journal every month is usually something to do with trust account violations. And this is something very simple that people don't think about, but that can land you in hot water if you're not paying attention. All right, so improving your processes, billing and collections. Let's talk about it, because again, this was my baby when I first started in family law, because I had no idea what I was doing and no one wanted to pay me. It was so strange. Okay, so first of all, rip off the Band-Aid. I get it, it's uncomfortable. And nobody wants to talk about money, especially if you just lost a hearing with your client, but they still owe you $2,000 for said hearing and things like that. Nobody wants to do it, but you do not work for free. And that was a super hard lesson for me to learn, because I just want experience right at that point. And so some cases, I just need to do this. I need the experience and it's fine. But you can't do that for every single case. And so you need to just be very comfortable with threatening to quit, and be very comfortable with just drafting a motion in order to withdraw until somebody pays you, which I did all the time, especially when clients will not contact you back after the second email. If I'm receiving radio silence, I go ahead, spend 5 minutes drafting up a motion in order to withdraw, send it to the client and say, hey, I plan on filing this tomorrow. And then magically, as if by some wonderful divine intervention, I get money in my LawPay account like that very day. It's so strange how that works out. But a lot of times too, you really do have to call their bluff on it, because you do not work for free. So just keep that in your head. And then also, if you have trouble with attorneys tracking their time, that was me all day long when I first started practicing. The best thing that I ended up doing was tracking my time hourly in Excel. And then not only that, I had to have penalties assessed because I was so bad about it. And what ended up being the best thing for me is that every day I had to send my hours to a senior attorney. So before I left the office, every single day, they got a copy of that spreadsheet for that particular day. And then once they could trust me, about a month later, they let me stop doing that, and I was able to do it myself, and I'm good to go. But sometimes you really do need that shame factor. It works very well for me. So especially, growing up Catholic, the guilt is very real. So just something to think about there. And then also they would assess penalties for the very, very bad offenders. So for instance, the ones that did once a month, they would put in their hours for the whole month. So those people actually would get some penalties assessed, some monetary penalties. But you can also do random other things, like for instance, take away their direct deposit privileges, which you wouldn't think would be that much of a burden. But honestly, there were a bunch of attorneys where that was the main motivating factor for them to get their hours in, is they just didn't want to have to cash the check from their phone. They just got very angry about it. So that was great. And then also use credit cards and online payments to your advantage. And what I mean by that, the number one thing that if you take anything away from this call or from the session, is that you should absolutely be adding a payment link to your signature block. And so for instance, every single email that I send out to clients, below my signature block is a link that just says pay now. a hyperlink. And then they click on that, it goes to my LawPay account. So there is never a question as to how to pay me. I never want a client to ever have to call into my office and say, hey, I'm trying to pay online. How do I do this? They can legitimately look at every or any single email that I've ever sent them, and it's there. And you'd be surprised at how much better and easier it makes things. Because also, say you're working on a case and then I'm emailing a client about it, but then I see that they have an outstanding balance. It's very easy then to just plug in at the end of that email and say, hey, client, also, I see that you owe about $500. You can click the link below my signature to pay. So you don't have to worry about finding the link somewhere and doing it. It's always there. You can refer to it at any time in your email. The best thing that you could possibly do, believe me. And then also you can send payment links for exact amounts, which are great. The clients can't change. So if I tell a client that they have to pay the mediator $1,000, and so they can pay my office and I can cut a check, they can't change that $1,000 because for some reason in family law, and I know this is going to shock everybody who does it, what'll happen at that point, even though I tell the client that he has to pay the $1,000 and the judge has ordered him to pay the $1,000, he will try to just pay $500 and say that his wife should pay the other $500. Oh, great. Family law is a lot of fun, but so it's easier when you can send in LawPay, we call it a quick bill, where you can send them this bill and they can't change the amount. So that's very nice. You can also see when they open it. So they can never lie to you and say they never got it. I've used that a lot. And also you can set clients up on payment plans, which is a great benefit for online payments and really using that to your advantage. Because if a client tells me that they can't pay, let's say their $3,000 bill, in family law, I have a unique view of the entire estate and I can see what's liquid and what's not. And so I see that if the client's telling me that and I know what their credit card limits are, then okay, I'm going to set them up on a payment plan. And so they can charge their credit card $500 every month until we get there. Because I'd rather get some money, I'd rather get some money than none, is how I view it and how I view payments for me, at least in my firm. And then AgeJR, if you want to know some special things that I did for that, because we had probably at least $500,000 between all of the 40 plus attorney firm in outstanding AR. And so we actually did a special thing with that to get as much money as we could in the door before the end of the year. So we made some plans, sent some emails out. I have all the templates for you. Let me know if you're interested in that. Super cool. And then also the biggest thing before I end this and get to Q&A is to utilize your evergreen retainers, especially for family law. And if you want the language for it, let me know. But essentially, it's a provision that you put into your fee agreement that I have the client sign by that says, hey, client, your retainer is X. In the event that your retainer ever dips below 40% of the original amount, you are required to replenish it up to the original. So that way you're always working against money and trust as opposed to having to chase it down after the fact. It's beautiful. It's wonderful. More people should be cognizant of it and stay on top of it. All right, and then I don't think we have time for authorization forms, but if you want them, they're there. We have them for free on our website. This is basically just another added layer of protection for you if you're taking credit card payments. Also, third party wanting to pay. So for instance, a lot of times we'll have like mom and dad want to pay the legal fees for their son. Well, then we have mom and dad actually execute what's called the third party payment addendum. So if you want that, let me know. And then there's a little bit more tips and tricks for getting money in the door that y'all can read and work with, but just be practical, be organized, and follow up on your invoices. Like a month or a week after you send out your invoices, you should get a list of everybody that has not paid, and you as the attorney should be following up with every single person on that list. And again, threatening to withdraw when you need to. PCI compliance we will not get to, but essentially it's just please stop emailing credit card information. Don't email it, just take it over the phone or online. I think that's it. If you have any questions, please let me know. This is my email address if I do not get to your questions, but thank you very much for attending. I appreciate it. And then, so do we have time for questions, Sasha, Kristen?
Hey, yeah, we definitely have time. We don't have any questions right now. So I was wondering, do you have any questions that maybe you get a lot that you could maybe touch on?
I would say a lot of them have to do with chargebacks and what they are. So if you need more information about that, refer to the slides, because I think it's also a little bit like, oh, how long do people have to do it? And it's a little bit off-putting too, because most credit cards clients have about 6 months to contest a charge after the fact. But things like Amex, they give you about 2 years. So make sure that you're maintaining your records, and also use your process to your advantage. So for instance, LawPay has like a ridiculous average when it comes to assisting and winning chargebacks for the clients. I think we're like 2 or 3 times the industry standard. So your processor should absolutely be helping you out in that instance that somebody institutes a chargeback.
All right, great. I do think we got a question. Are the authorization forms you mentioned accessible on lawpay.com?
Yeah, it should be under resources, but easiest thing to do is shoot me an email, jturk@lawpay.com, and I can send you that because I don't think I've put up the third-party payment addendum yet. So that's being uploaded, but you can email me right now and I can send that to you.
Okay, and we'll try to add a link to that in the follow-up email along with the slides to whoever asked that question in the chat. All right. We are gonna come in with the outro. Jordan, do you have any last thoughts?
Nope, all good. I hope I was at least a little bit informative for everybody. Really, I'm truly passionate about payments and getting paid just from my own personal experiences. So really, truly, if you need any help for your firm or you're trying to figure out what you need to do to optimize it, please let me know. I'd be happy to help.
Well, that's all the time that we have for today. I would like to thank our sponsor, LawPay, and all of you for attending our webinar today as part of the LTRC Industry Insight Series. I would also like to thank you, Jordan, for presenting today. If you are curious about future webinars, please check out the ABA LTRC page or follow our Twitter at LTRC for updates. You can keep up with LawPay at lawpay.com. We will now conclude the webinar. Thank you, everyone.